Hello, my name is Boyd Adams. I want to make a video on some problems that exist in our judicial system for a long time. I was in law enforcement for 27 years. I retired in 2018. I served 2 terms as an elected police chief. And since then, I have been on an awakening call, I guess you can say, learning the truth about the judicial system, number one, learning the truth about the world we live in. I'm sure everybody by now sees that there's some major things going on in our country, and there's changes coming, and absolutely nothing at all can stop what is coming. So this video is mainly for police officers, sheriff deputies, state troopers to listen to what I have to say. Do your own research. I want you to think that I don't know what I'm talking about, and find your own truth in what I'm saying. Everything I'm going to go over with you tonight is 100% straight from Supreme Court decisions, constitutional law, and I'm going to stay on that. So nothing is being pulled out of a hat. This is all 100% factual. It's out there for anyone to learn it, and it's very important for, especially for the officers, because the liability rests on the officers, and it's not fair, and it's really upsetting. This little deal here I have, it's an article that came out June 23rd, 2023. Doing what's right after 81 years, judge rules administrative court systems are illegal. That's the court systems we have in all 50 states. State courts, municipal courts, or administrative courts. Okay, I'm going to get started. Common law, the facts. Common law is the beginning of all law, and its imperfection, and in its perfection is the absence of all law. And in today's society, it is known as public policy. Common law, summed up in simple terms, is the will of the people and will manifest itself in the separate cases as people so rule. When they're conscious and a sense of fair play, common law is a law that is common to all people. The law is common sense and is the law of the Creator God of the universe. Do unto others as you would have them do unto you. Common law supersedes all law and is superior in all cases to statutory law, codified law, and rules and regulations. Common law establishes constitutions, as all power is inherent in the people. Common law establishes through the Constitution all restrictions on the government. Constitutions never give the government power for legislating people. Government only has the power to legislate the workings of the different functions of the various departments to allow the people life, liberty, and the pursuit of happiness. Constitutions can never establish common law, for then all power would be in the people, but would be in the Constitution, and it is only a piece of paper. And the people's right to address grievances or to amend, change, or address any problem could not be. The Creator God created man. Man with help created government. Government started corporations. The Creator rules over man. Man rules over government. and government rules over corporations. Governments are mere pieces of paper to be altered and changed to the whim of the living souls. Corporations are mere pieces of paper that government can change and alter at their whim. The Creator is superior over man, government, and corporations. Man is the superior to government and corporations. If man says they do not exist, they do not exist. Simply said, common law, public policy, the will of the people, a law common to all people. Constitutional case laws. Bennett versus Boggs. Statutes that violate the plain and obvious principles of common right and common reason are null and void. Davis versus Welsher. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which abrogate them. Miller versus U.S. There can be no sanction or penalty imposed upon one because of the exercise of constitutional rights. Norton versus Shelby County. An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, it creates no office. It is in legal contemplation and inoperative as though it had never been passed. Cooper versus Aaron. Any judge who does not comply with his oath to the Constitution of the United States wars against the Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. The United States Supreme Court has stated that no state legislator or executive or judicial officer can war against the Constitution without violating its undertaking to support it. Schuer versus Rhodes. By law, a judge is a state officer. The judge then acts not as a judge, but as a private individual in person. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are not voidable, but void, and of no legal force or effect. The United States Supreme Court stated that when a state officer acts under a state law in a manner violated to the federal Constitution, he comes into conflict with the superior authority of that Constitution, and he is, in that case, stripped of his official and representative character, and is subjected in his person to the consequences of his individual conduct. The state has no power to impart to him any immunity for responsibility to the supreme authority of the United States. Miller versus U.S. Can be no sanction or penalty imposed upon one because of his exercise of constitutional rights. Murdoch versus Pennsylvania. No state shall convert a liberty into a license and charge a fee therefor. Let's say it again. Murdoch versus Pennsylvania. No state shall convert a liberty into a license and charge a fee therefor. Fishing licenses, hunting license, driver's license, license plates, none of that is legal. Don't have to have them. Shuttlesworth versus City of Birmingham, Alabama. If the state converts a right, liberty, into a privilege, the citizen can ignore the license and fee and engage in the right, liberty, with impunity. Elmer versus McCammon. The Sims versus Ahern's. The practice of law is an occupation of common right. Because of what appears to be a lawful command on the surface, many citizens, because of their respect for what appears to be law, are cunningly coerced into waiving their rights due to ignorance. Let me say that again. It says a lot in that statement. The practice of law is an occupation of common right. Because of what appears to be a lawful command on the surface, many citizens, because of their respect for what appears to be law, are cunningly coerced into waiving their rights due to ignorance. Appears to be law. U.S. versus Minker. Supreme Court of the United States, inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with another artificial person, the imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, court, etc., can concern itself with anything other than corporate, artificial persons and the contracts between them. So, when we were born as American state citizens, American state nationals, and they created a birth certificate and misled our parents. Our parents signed as an informant on the birth certificate. They made us United States citizens. Well, the all caps name is where on the birth certificate and the Social Security card. They're bonds traded on the stock market just thousands of times. They're worth multi-millions of dollars. Those bonds prepay all of your debt. Every loan you ever had has been prepaid by those bonds, and you pay it back. That's a whole nother topic we're not going to get into, but I'll just know that all your debt's been prepaid since 1933, and you never owed anyone anything. You've always been the creditor. But anyways, they created the all caps name on these birth certificates. So if you notice on every financial statement, every bill, every court document, it's the all caps name for the defendant in court, and your loans and stuff. It's all the all caps name. That's because they're corporations, and the U.S. citizen is a corporation, the fictitious entity that they can contract with. They can't contract with you because you're a living person. That's why you need to have an attorney represent you in court, because you can't speak for yourself because you don't exist. You're supposed to be lost at sea in the corrupt system. That's how it is. You know, the deception in words, like a person is in the law, Admiralty Maritime Law, the judicial system we have now. A person is a fictitious entity, a corporation. I mean, we're persons. We think we're persons, but according to the law, no, because they changed that years back so that people would be fooled or be misled, to be able to contract with these people and put people in jail without full disclosure on what is really going on. You know, last I heard, a felony gets, they withdraw $1 million from the Social Security accounts, and the misdemeanors, I don't remember, and it might be a little less and maybe a little more on the felonies. I'm not too sure about that, but I know they withdraw on each, and that's distributed however it's distributed. without ever telling you. They act as trustees to the trust accounts. It's a big mess, and it's sickening. But it's about to be over. Okay. So the living person is the all caps. The fictitious entity is the all caps name they created, and the you're lost at sea with your God-given name, upper and lowercase. What I've done is I've changed my status. I've changed my political status. It's several documents I had to do and get notarized and file with the federal government, state government, district courthouse. And I took my God-given rights back and claimed my birthright back as an American state national. People say that's sovereign citizen. That's bullshit. It's not sovereign citizen. That's the two words don't even go together. Everyone is sovereign. We were born sovereign. Jesus Christ is sovereign. That's a good thing. That's a great thing. It's freedom. It's being able to do what we were meant to do when we were born on the land as a child, before our rights were stolen, and we were taught wrong from then on. I mean, it's been lie after lie after lie after lie, and everybody's going to be learning that pretty soon. The Great Awakening is happening, and people are learning daily the truths out there of what's really going on, and it's going to floor a lot of people. It's just unbelievable, but it's true, and you'll see. But I'm concerned about this right now because the officers, people are learning this, and the officers need to make some adjustments to stop themselves from getting sued, criminal charges, whatever it may be. If this is important to me, it's important that every officer know this and adjust where it needs to be adjusted. McNally versus U.S. versus Holzer. Fraud, in its elementary common law sense of deceit, includes the deliberate concealment of material information in a setting of a fiduciary obligation. A public official is a fiduciary toward the public. If he deliberately conceals material information from them, he is guilty of fraud. The law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. Fiduciary, your trust account, the money, the deception, failure to disclose all of that, failure to disclose that a living person does not have to participate in the courts. They don't have to contract because every living person is owed natural law, American common law, God's law, not admiralty maritime law. Higgins versus Levine. A judgment rendered by a court without personal jurisdiction over the defendant is void. It is nullity. Maine versus Tibotot. I don't know. It's Tiboutot. Jurisdiction can be challenged at any time, and jurisdiction, once challenged, cannot be assumed and must be decided, but cannot be decided by the same court. Has to be a different court. Stock versus medical examiners. Where a court's power to act is controlled by statute, the court is governed by the rules of limited jurisdiction. The courts exercising jurisdiction over such matters must proceed within the structures of the statute. The state citizen is immune from any and all government attacks and procedure, absent contract. Dred Scott versus Sanford. Or as the Supreme Court has stated clearly, every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Now, consent, you have the right to remain silent. Anything you say can and will be used against you to court of law, so on and so forth. And they understand. Okay, I understand. Okay, that is considered a consent to them. I have a problem with that. Because is it disclosed to that person? Or, excuse me, not a person, because they're a real living person. Is that disclosed to that man or woman that they don't have to consent to anything because they have the right to American common law, and they have the right, constitutional rights that can't be violated? Are they ever told that? Did we ever tell any suspect that? No, we haven't. It's not right. It's horrible what we have been going through, and uneducated, not told. We go to the police academy and it's statute, criminal law, traffic law, criminal law, traffic law, all statutes, and then the city ordinances with their little running an electrical line in the yard or whatever, just stupid stuff, and tearing people's houses down and then billing them for it. That you can't do that. I mean, they're violating the Constitution of the United States of America. These people, with their houses being torn down, have the right to a home. Whatever that home looks like, that's their business. That's their home. City can't just vote and say we're going to go tear it down. No. And that's going to create problems. But for policemen, adjust where it needs to be adjusted. I mean, every one of us are grown men and women and can make bright decisions. I know that most law enforcement is in the profession for the right reason, to help people, because it's a passion. It's something you love to do. It's what I love to do. I'd do anything for anybody. Helping people is just what makes me happy. That's always what I've done. So don't get discouraged. I just think it's important y'all need to know this stuff, because, and you're going to see here a little later, I'm going to keep reading constitutional laws and cases and by the Supreme Court, and it's going to say that all statutes, codes, ordinances are not laws. They're unconstitutional due to lack of due process and not enforceable on the people. None of them, all of them. Okay. So that's a wake up call there, guys. I mean, and who's telling us this? Nobody's telling nobody. It's not being talked about, but they're about to drop the hammer, and people are learning this. I mean, I learned it. It's available for anybody to learn it. The Federation taught me, the United States of America Federation taught me what I'm telling you. Porter versus State. When governments enter the world of commerce, they are subject to the same burdens as any private firm or corporation. U.S. versus Burr. Banks of the United States versus Planters Bank of Georgia. Every government, agency in the United States, every police department, every sheriff's office is a corporation. They all have Dun & Bradstreet's numbers. You can look it up on Dun & Bradstreet website, and you'll find they have a Dun & Bradstreet. Every city has a corporate limits, incorporated cities. They're all governments. So what this is saying, Porter versus State, when governments enter the world of commerce, governments becoming corporations, they've entered the world of commerce, they are subject to the same burdens as any private firm or corporation. Think about that for a little while. I mean, I don't have to tell you what I'm thinking. You know what's the deal. Shapiro versus Thompson. Further, the right to travel by private conveyance for private purposes upon common way cannot be infringed. No license or permission is required for travel when such travel is not for the purpose of commercial profit or gain. On the open highways operating under license and commerce, the rights of the individuals are restricted only to the extent they have been voluntarily surrendered by citizenship to the agencies of government. Voluntarily surrendered. Do you know you surrendering your right to travel? You ever told when you go to DMV, I need to do this for full disclosure. I need to tell you, you don't need a driver's license if you're not driving commercially, for hire, driving people, whatever. No, they don't tell you that. It's null and void. It's ridiculous. It's clear as day. There's tons of case laws that state you don't need a license, forced insurance, or registration, or license plate, period. Poindexter versus Greenhow. Brady versus U.S. Waivers of constitutional rights. Not only must they be voluntary, they must be knowingly, intelligent acts done with sufficient awareness. There it is. Never have sufficient awareness. Fraud destroys the validity of everything into which it enters. That is Nudd versus Burroughs. Fraud vitiates everything. U.S. versus Throckmorton. Whereas officials and even judges have no immunity, officials and judges are deemed to know the law and sworn to uphold the law. Officials and judges cannot claim to act in good faith in willful deprivation of law. They certainly cannot plead ignorance of the law. Even the citizen cannot plead ignorance of the law. The courts have ruled there is no such thing as ignorance of the law. It is ludicrous for learned officials and judges to plead ignorance of the law. Therefore, there is no immunity, judicial or otherwise. It matters of rights secured by the Constitution of the United States of America. See Title 42, U.S.C. Section 1983. When lawsuits are brought against officials, they must be brought against them in their individual capacity, not their official capacity. When federal officials perpetrate constitutional torts, they do so ultra vires, beyond the powers, and lose the shield of immunity. William versus the U.S. Department of Agriculture. It is the duty of all officials, whether legislative, judicial, executive, administrative, or ministerial, to so perform every official act as not to violate constitutional provisions. This is Penhallow versus Doan's administrators. The contracts between them involve U.S. citizens which are deemed as corporate entities. Remember, the birth certificate was created and made you a U.S. citizen from an American. The contracts between them involve U.S. citizens which are deemed as corporate entities. Therefore, U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. Wheeling versus Steele Corporation versus Fox. Alexander versus Bosworth. party cannot be bound by contract that he has not made or authorized. Free consent is an indispensable element in making valid contracts. You have to clearly consent to participate with the police, with the courts, because the system is, they have to try to make it as lawful as possible. It's crazy. Once you learn it and you know, you can't unsee it. You really can't. It's terrible. Let's see. Barbarian versus Lucier. The right of the citizen to drive on the public street with freedom from police interference, unless he is engaged in suspicious conduct associated in some manner with criminality, is a fundamental constitutional right which must be protected by the courts. People, let's see. The rights of a citizen to travel. This is Pontius versus McLean. The right of a citizen to travel upon the public highways and to transport his property therein by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under the right of life, liberty, and the pursuit of happiness. And then there's several other case laws, same thing, just listed. Edward versus California, Twining versus New Jersey, Williams versus Fears, Crandall versus Nevada, the passenger cases versus Holtard, U.S. versus Guest, Griffin versus Breckenridge, and it goes on and on. No state government entity has the power to allow or deny passage on highways. Travel is not a privilege requiring license, vehicle registration, or forced insurance. Chicago Coach Company versus City of Chicago. The fundamental right to travel is not a privilege. It is a gift granted by your Maker and restated by our founding fathers as unalienable and cannot be taken by any man, government, man-made law, or color of law known as private code, secret, or statute. As general rule, men have natural right to do anything which their inclinations may suggest, if it be not evil in itself and in no way impairs the rights of others. That's Newman, 1858. Traveling is passing from place to place, act, performing journey, and travelers in person who travels. Archie. Traffic infractions are not a crime. People versus battle. The use of the highway for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and individuals cannot rightfully be deprived. Chicago Motor Coach versus Chicago. The right of a citizen to travel upon the public highways and to transport his property thereon, either by carriage or automobile, is not a mere privilege which a city may prohibit or permit at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Thompson versus Smith. Even the legislature has no power to deny to a citizen the right to travel upon the highway and transport his property in the ordinary course of his business or pleasure. though this right may be regulated in accordance with public interest and convenience. Chicago Coach Company versus City of Chicago. The right of a citizen to travel upon a public highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that one who makes the highway his place of business. Commercial driving, you need a license if you're driving for hire. Constitutional law. Citizen's right to travel upon public highways and transport his property thereon in the ordinary course of life and business is common right. The right of a citizen to do so is that which he has under his right to enjoy life and liberty, to acquire property, and to pursue happiness and safety. Automobiles and highways. Citizens' right to travel upon public highways includes right to use usual conveyances of time, including horse-drawn carriage or automobile, or ordinary purposes of life and business. For ordinary purposes of life or business. Okay. Constitutional law. A law-chilling assertion of rights. If a law has no other purpose than to chill the assertion of constitutional rights by penalizing those who choose to exercise them, then it is patently unconstitutional. Shapiro versus Thompson. I'm stressing the driving without a license because my sister was stopped about 3 months ago for driving without a license plate because she don't need one. She's traveling, in her personal automobile, not for hire. She went to the grocery store and was just coming straight home. She was stopped, issued citations. The police department was served prior to her being stopped with the travel packet saying that she had the law says you don't need a license, registration, or insurance. We're all self-insured through the trust, their Social Security trust. I mean, it's worth $200-300 million. It's insane. It's so much. That's where the insurance gets paid anyway from your trust, and you pay it also. You just don't know. So all this was sent to the police department. Clearly obvious that she did not break any laws. Well, she was issued citations and instructed to travel home, park it, and not put it back on the road. Well, he can't say that because she's not breaking a law. So he can be ignored just like the law states. And same officer stopped her again, wrote her 7 citations for something, and impounded her car. Her car has been impounded for 2.5 months, almost 3 months now, unlawfully. So it's stolen. That's what it is, a theft, more or less, because she broke no law. They're working under color of law, and they haven't tried to make a remedy. Not a single attempt was made. I mean, I can't let it go. I'm not letting it go. And it's about to be resolved, but it's people that are violating people's constitutional rights, there's a place for them to go now. I know who to call. I know what to do. It's not like it used to be. Like I said, things are changing. And I've tried to make that clear, but I'm ignored. I mean, I've been trying to call the chief. There's over a year, and he won't call me back. And I'm the retired police chief from the same agency, which is insane. Okay. Under USC Title 42, 1986. Now, speaking of public notice, and I'll tell you a little story after I read this. Under USC Title 42, 1986, action for neglect to prevent, it states, every person who having knowledge that any wrongs conspired are to be done and having power to prevent or aid in preventing neglects or refuses so to do so shall be liable to the party injured. The means of knowledge, especially where it consists of public record, is deemed in law to be knowledge of the facts. As the means of knowledge, it appears that the individual had notice or information of circumstances which would put him on inquiry, which if followed would lead to knowledge, or that the facts were presumptively within his knowledge. He will be deemed to have had actual knowledge of the facts and may be subsequently liable for any damage or injury. You therefore have been given knowledge of the facts as it pertains to the conspiracy to commit fraud against me. They were served with the travel packet, making all the laws clear. On the stop, I tried to call the chief to let him know that my sister's rights were being violated, for him to do something about it, because that's his job, you know. And he didn't answer. I saw emailed, didn't reply, so I emailed him again, and I told him, I said, you are failing to do your job, and I will see to it that you're removed for not doing your job if you do not stop my sister's rights from being violated. I was upset, and I had every right to be, and I still have every right to be, because my sister is handicapped, and she's still without a vehicle, and she broke no laws. So it's very frustrating, especially when it was served. I mean, they knew it was right there for them, just like the law just said. So after her second stop, where the car was towed, 3 weeks later, the police come to my house with a warrant for my arrest. Arrest me for threatening a public official, filing false public record, like the law just said for me to do, file the public record. Filing false public record, impersonating a public official, and I mean, there's some other ridiculous stuff that makes no sense at all. I'm at the time, I was the state marshal for the Louisiana Assembly. I am a public official, a lawful public official on the land and soil. The Louisiana Assembly is one of the 50 state assemblies, the 50 Union of States. The lawful government on the land and soil. People don't understand that, don't see that, whatever, but everyone's going to learn that the land and soil is the jurisdiction we live on. So the jurisdiction is that of the people. The Louisiana Assembly is the people, the governed by the people. So I'm going to keep going. Needless to say, that arrest was just crazy. But I can't let it go. I'm not going to let it go, because absolutely not. Failure to reveal the material facts of a license or any agreement is immediate grounds for estoppel. So you go to DMV and they don't tell you you don't need a license. There you go. Okay. A law which authorizes the taking of a private property without compensation cannot be considered as due process of law in a free government. Chicago versus Chicago Company. The binding shackles of government is the Constitution, to wit, the laws of nature are the laws of God, whose authority can be superseded by no power on earth. A legislature must not obstruct our obedience to him, from whose punishments they cannot protect us. All human constitutions which contradict his cannot protect us. All human constitutions which contradict his, God's laws, we are in conscience bound to disobey. Robin versus Hardaway. In the state where, an unconstitutional law is not a law. It confers no right, imposes no duties, and affords no protection. Norton versus Shelby County. The rights of the individual are not derived by governmental agencies, either municipal, state, or federal, or even from the Constitution. They exist inherently in every man by endowment of the Creator, and are merely reaffirmed in the Constitution and restricted only to the extent that they've been voluntarily surrendered by the citizenship to the agencies of government. The people's rights are not derived from the government, but the government's authority comes from the people. The Constitution but states, again, these rights already existing and were when legislative encroachment by the nation, state, or municipality invade these original and permanent rights, it is the duty of the courts to so declare and to afford the necessary relief. City of Dallas versus Mitchell. A constitution is designed as a supreme enactment, a fundamental act of legislation by the people of the state. A constitution is a regulation direct from the people acting in their sovereign capacity, while a statute is legalization from their representatives, subject to limitations prescribed by the superior authority. Ellingham versus Dye. The liberty guaranteed by the Constitution must be, An unconstitutional act is not law. It confers no rights, imposes no duties, so on and so forth. As inoperative as though it had never been passed. Norton versus Shelby County. Let's see. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionally dates from the time of its enactment and not merely from the date of the decision so branding it. No one is bound to obey unconstitutional law, and no courts are bound to enforce it. All laws which are repugnant to the Constitution are null and void. Chief Justice Marshall, Mayberry versus Madison. Just about done. The people are sovereign. People are supreme, not the state. Waring versus Mayor of Savannah. The people of the state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for the people to know. The people insist on remaining informed so that they may retain control over the instruments they have created. And that is Added Statutes 1953, 1588, page 3270, section 1. The people are the recognized source of all authority that are municipal, and to this authority it must come at last, whether immediately or en route. Barnes versus District of Columbia. The government is but an agency to the state being the sovereign people. State versus Chase. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. And the law is the definition and limitation of power. The Congress cannot revoke the sovereign power of the people to override their will, as thus declared. Perry versus United States. The doctrine of sovereign immunity is one of the common law, immunities and defenses that are available to the sovereign. Will versus Michigan Department of State Police. The people of the state, as the successors of its former sovereign, are entitled to all rights which formerly belonged to the king. Private corporate state. Municipal policy enforcement. Nothing is gained in an argument by calling it police power. Henderson versus City of New York. An officer who acts in violation of the Constitution ceases to represent the government. Brooksfield Construction Company versus Stewart. That an officer or employee of a state or one of its subdivisions is deemed to be acting under color of law as to those deprivations of rights committed in the fulfillment of the task and obligations assigned to him. Monroe versus Page. Actions by officers and employees, even if authorized or in excess of authority, can be actions under color of law. Stringer versus Dilger. The police power of the state must be exercised in subordination to the provisions of the United States Constitution. Beckenham versus Wanley. With regard particularly to the United States Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any authority. Donnelly versus Union Sewer Pipe Company. The officers of the law in the execution of process are required to know the requirements of law, and if they mistake them, whether through ignorance or design, and anyone is harmed by their error, they must respond in damages. Roger versus Marshall, United States, use of Rogers versus Coughlin. It is a general rule that an officer, executive, administrative, quasi-jurisdictional, judicial, ministerial, or otherwise, who acts outside the scope of his jurisdiction and without authorization of law may thereby render himself amendable to personal liability in a civil suit. Cooper versus O'Connor. Public officials are not immune from suit when they transcend their lawful authority by invading constitutional rights. Alficio versus Woodard. Public servants, officers, judges not immune from suit. Immunity fosters neglect and breeds irresponsibility, while liability promotes care and caution, which caution and care is owed by the government to its people. Civil rights. Rabin versus Rowan Memorial Hospital Incorporated. Government immunity in Land versus Dollar. The court noted that when the government entered into a commercial field of activity, it left immunity behind. Brady versus Roosevelt. FHA versus Burr and Kiefer versus RFC. The high courts, through their citations of authority, have frequently declared that where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipality, etc., waives any immunity to counters, cross-claims, and complaints by direct or collateral means regarding the matters involved. Ludenbeck versus Tekla. When enforcing mere statutes, judges of all courts do not act judicially. And thus are not protected by qualified or limited immunity. Owens versus City. Bothke versus Terry. But merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. Thompson versus Smith. Keller versus PE, FRC versus GE. Immunity for judges does not extend to acts which are clearly outside of their jurisdiction. Bowers versus Hazel. Rhodes versus Houston, Mueller versus Wechtel. Judges not only can be sued over their official acts, but could be held liable for injunctive and declaratory relief and the attorney's fees. Lesma versus Justice Court. All right. It is one of the fundamental maxims of the common law that ignorance of law excuses no one. Where there is no jurisdiction, there is no judge. The proceeding is as nothing, such as been the law from the days of the Marshalsea. Bradley versus Fisher, Manning versus Ketchum. And just a couple of ones on here. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act of treason. U.S. versus Will. Cohens versus Virginia, so on and so forth. Okay, corpus delicti. Victimless crimes do not exist. Okay, we all know that state statutes, there's tremendous amount of them that are victimless crimes. There has to be an injury or there has to be damage, and period. That's it. Anything else is not a crime. Proof of jurisdiction on the record. The plaintiff prosecutor has standing corpus delicti, which means a victim. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the constitutional rights. Scherer versus Cullen. With no injured party, a complaint is invalid on its face. Gibson versus Boyle. Supreme Court ruled, without corpus delicti, there can be no crime. In every prosecution for crime, it is necessary to establish corpus delicti, the body or elements of the crime. Injury or damage. None of those, no crime, no arrest, no ticket. Proof of jurisdiction appearing on the record that the defendant is subject to rules, codes, and regulations. All codes, rules, regulations are applicable to the government authorities only, not human creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking in due process. Rodriguez versus Ray Donovan, U.S. Department of Labor, 1985. Let's say that again. All codes, rules, and regulations are applicable to the government authorities only, not human creators, in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking in due process. Rodriguez versus Ray Donovan, U.S. Department of Labor, 1985. That's it in a nutshell. And this is the supreme law of the land, cannot be ignored, has to be followed. Nothing overrides it, period. So, just, it's important y'all know. Okay. UCC 1201, general definitions. Person means an individual, corporation, business trust, estate, trust, partnership, limited liability, association, joint venture, and government. Then you might say individual could be a person. Look up individual. That's a whole nother. Governmental subdivision agencies are instrumentality, public corporation, or any other legal or commercial entity. American Law and Procedure, Volume 13, page 137, 1910. The word person and its scope and bearing in law, involving as it does legal fictions and also apparently a natural being, it is difficult to understand, but it is absolutely necessary to grasp, at whatever cost, a true and proper understanding to the word in all the phases of its proper use. A person is here not a physical or individual person, but the status or condition with which he is invested. Not an individual or a physical person, but the status or condition or character borne by physical person. The law of persons is the law of status or condition. Also see Uniform Commercial Code. Code creates a corporate state of the United States, the federal corporation, as opposed to one of the de jure several states. UCC 1201, general definition, state means a state of the corporate United States, as opposed to USC Title 28, Part 6, Chapter 176, Subchapter A, 3002, Definitions 14. State means any of the de jure union states of the several states. Proof of jurisdiction appearing on the record that the alleged defendant is not a sovereign, status corrected, American state citizen, or American state national. In the United States, the people are sovereign, and the government cannot sever its relationship to the people by taking away their citizenship. Alfraham versus Rusk. Also see the people of a state are entitled to all rights which formerly belonged to the king. Also, let's see, that's your U.S. Supreme Court, Wilson versus Omaha Indian Tribe. In common usage, the term person does not include the sovereign, and statutes employing the word are ordinarily construed to exclude. U.S. Supreme Court, since in common usage the term person does not include the sovereign, statutes employing the term are ordinarily construed. So there's several of them saying that statutes just don't go to the living sovereign. We don't live by statutes, we live by God's law. And that is the jurisdiction over us, not admiralty, maritime, police, no. Men are endowed by their Creator with certain unalienable rights, life, liberty, and the pursuit of happiness, and to secure, not grant, or create these rights, governments are instituted. The property or income which a man has honestly acquired, he retains full control of. Budd versus People, State of New York. By the way, you don't have to pay payroll taxes. You never did. It's voluntarily. I signed some paperwork and sent them to the Treasury, and I was able to back up 13 years and cancel out all my tax returns. But you have to be an American to do that, from what I understand. Shapiro versus Thompson. Let's see, we went over that. That's the same things about the traffic. You have the right to travel. I think that's pretty clear by now. Hope. Or rights secured by the Constitution are involved, there can be no rulemaking or legislation which is would abrogate them. Miranda versus Arizona. The state cannot diminish rights of the people. Hurtado versus California. Alexander versus Bosworth did that. Personal involvement in deprivation of constitutional rights is a prerequisite to award of damages, but defendant may be personally involved in constitutional deprivation by direct participation. Failure to remedy wrongs after learning about it, creation of a policy or custom under which constitutional practices occur, or gross negligence in managing subordinates who cause violations. Gallegos versus Haggerty. We talked about the government being an artificial persons and just a figure of the mind. And this is something we see a lot in court. Porter versus Porter. The practice of an attorney after filing an affidavit on behalf of his client asserting that the status of the client is not approved, inasmuch as not only does the affidavit become hearsay, but it places the attorney in a position of witness, thus compromising his role as an advocate. It's Commercial Crimes, District of Columbia Code 27 CFR 7211, Code Enforcement Officers, Law Enforcement Officers, LEOs, commercial crimes, any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, so on and so forth. Which means that the so-called judge is actually a clerk working for the prosecutor when acting to enforce a statute. And its subsequent amendments to the present date, the judge of the municipal court and state court is acting as an administrative officer and not a judicial capacity. Courts administrating or enforcing statutes do not act judicially. They act as an extension, as an agent involved for the involved agency, but only in a ministerial and not a discretionary capacity. Thompson versus Smith. Keller versus PE and FRC versus GE. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. K.C. Davis, Administrative Law, Westlaw, 1965 edition. An officer who acts in violation of the Constitution ceases to represent the government. Brooksville Construction versus Stewart. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Therefore, any so-called order the clerk masquerading as a judge issues is a fraud and a nullity. Like a warrant for arrest is a fraud and nullity, and a fine is a fraud and nullity, and he is fully liable in his personal capacity and has no judicial immunity. Where any state proceeds against a private person, the immunity. When enforcing mere statutes, judges of all courts are not acting judicially, and thus are not protected by qualified or limited immunity. Bothke versus Terrio and versus City. All right, okay. Black's Law Dictionary, 6th edition, page 868. Kangaroo court. Term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or the tribunal. Maxims of Law, Black's Law Dictionary, 9th edition, page 1832. Fraud and justice never dwell together. Okay, all District of Columbia territorial courts, which is state courts, city court, are using their Uniform Commercial Code, which is controlled and regulated by the Unidroit Treaty, International Institute of the Unification of Private Law, which the United States Incorporated has been a signatory to for over 30 years, which is unconstitutional because the treaty power can only be used externally. Today, it is enough to highlight some of the structural and historical evidence suggesting that the treaty power can be used to arrange intercourse with other nations, but not to regulate purely domestic affairs. Bond versus United States. And you have the courts have no authority to use Unidroit Treaty in America, and they use it of the Uniform Commercial Code is unconstitutional. The government of the United States is one of limited powers. It can exercise authority over no subjects except those which have been delegated to it. Congress cannot legalize, enlarge, or our federal government jurisdiction, nor can it enlarge under the treaty-making power. Mayor of New Orleans versus United States. United Nations clerks masquerading as judges in the 50 states are impersonating public officials, which is a felony. A person commits an offense if he impersonates a public servant with intent to induce other to submit to his pretended official authority or to rely on his pretended official acts, or knowingly purports to exercise and function of a public servant or of a public office, including that of a judge and court, and the position of or office through which he purports to exercise a function of a public servant or public office has no lawful existence under the Constitution or laws of this state or of the United States. An offense in the section which is a felony. And that is Owens versus Independence. Where there is no jurisdiction, there is no judge. The proceeding is as nothing. such as been the law for the days since the days of Marshall, Bradley versus Fisher, Manning versus Ketchum. Avoid judgment is one from its inception and complete nullity with and without legal effect. Okay, so I'm done. And if you all can see, I don't believe anybody can say that that system is one created by God and supported by God. The deception, and not everyone may be aware of this, judges may not be aware, attorneys may not be aware, but attorneys are considered foreign agents, and they have to register with FARA, a federal agency, as being foreign agents. It's crazy, but it's true. We've been deceived. We haven't been told the whole truth, and this is happening. It's happening. Even if I wouldn't have told you ahead of time so people can start correcting, it's happening anyway. Nothing can stop what is about to happen. My understanding, I from a pretty reliable source, I read that all governments, courts, lawyers, judges are going to be shut down and retrained in natural law. And everything's going to be a fresh start. From understanding, they had 700,000 sealed indictments that are being served. Maybe it's down to 400,000. I'm not sure. Don't quote me on the numbers, but there's some. That there is a emergency act signed by President Trump, a state of emergency for the violations of human rights in this country. So, that's been signed into law since he was president his first term. He's in his second term now and going to be in his third. He's been the commander-in-chief. He never left. And that's pretty obvious for anybody that's not living under a rock to see that he has never left. So I hope everyone takes this to heart and does their own research. I don't want to see anyone in trouble. I don't want to see anyone sued. I just want people to do the right thing. We are at a point, we're living in biblical times, and we should be uniting and coming together all as one, because we are all one. We all are connected through our Creator. And that is so important for what's coming. A lot of people are going to be surprised. It's what's coming is going to be outstanding. It's going to be unbelievable. It's just there's beautiful times ahead of us. Words can't explain the greatness that is coming. And I know it with a full heart. What do we know about religion and what the facts are, and it's really good, and it's a relief to know the truth about the world we live in and who we are. Because when you find out who you are and who you really are, it's going to change your life, and for the better. We are all living souls. We're spiritual beings. We never die. Death is an illusion. That this body that we have is just temporary. You know, we live for eternity, forever. We've been here thousands of years, you know. Um, and when you start to learn all this, you won't question it once you find out who's the teacher. So it's pretty amazing. It's been a rocky road, but it's been a wonderful, outstanding blessing to have been down this road for the last 4.5, 5 years. It's been tough. I'm not gonna lie, and it's gonna be tough when people learn some things. It's gonna be very tough, but just know everything is okay, and the man upstairs that's already here is in control. If I can help anybody with anything, anybody has any questions, I'll leave my email at the bottom of the video in the notes. Shoot me an email, and whatever I can do to help, I'm there to help. You know, I'm sure people are thinking, "Oh man, you know, I can't believe you said all this." Everything I told you tonight was straight from the books, straight from the laws, from the Supreme Court of the United States. I'm not afraid. Truth can never hurt you, but a system that has to change words and finagle to get jurisdiction and look, that system is not one of God, and it has no business being in the United States of America. Period. And it's not going to be much longer. And that's not my choice. It is my choice. I'm a citizen. I'm an American, and I don't want a system like that. And it's for the people to say they don't want a system like that, and to stand up. You know, we thank God for Donald Trump and JFK Jr. and Miss Anna Von Ritz. These people have been calling out this corruption for a long time. There is a reason, people, that they want Donald Trump dead so bad. Two homicide attempts in 2 weeks, and there's plenty more before that that have not went public. And then a drone flew over his bedroom window, tried to shoot through the window while he was asleep. So many different times that we don't know about, or some people don't know about. They want him gone for a reason. This is one of them. The judicial system, that he's cutting it, and the elite pedophiles, Satanists, you know. Satanists created this judicial system. That's where, and if you do your research, you will learn that is where it implemented by Satanists. Our world has been run by Satanists. And don't believe me. I don't want y'all to believe me, because I'm telling y'all, don't believe me. I want y'all to think I'm lying my ass off. Do some research and learn it for yourself, so that nobody can talk behind my back, because I'm being straightforward with everything I said. And it is what it is. And it's not a lie. So, but God is back in control. Jesus Christ is back in control of our world, and he has won the battle between good and evil. And evil has somewhere to go now, because the new earth that's coming, and I'm sure everybody's heard new earth, the statement said about new earth is right around the corner. Actually, it's already here. And there's no place for evil, no place. It's all about love for humanity, helping people, unconditional love, resonating. It's 528 hertz, love energy. It's Guys, we've been lied to about everything. You know, we need to learn everything over again. And I mean, it's not the time. I've been, it's probably almost 2 hours. It's enough. So, but thank y'all for listening. And please, you know, I can't tell you what to do, but if it were me, I would make corrections where corrections need to be made ASAP. Thank you, and God bless you all. Be safe. Have a good day.